NACDL is the association of the nation's criminal defense bar.
So I don't know if this is common practice for a lot of folks to use experts in suppression hearings, to present them in our case in chief. I know where we come from, a lot of the time the judges will be like, well, after the cop, we're done, right? So this is something that, honestly, it kind of starts with, let's start with the basics. Sometimes we can use the cops in our suppression hearings to get in that opinion testimony that's helpful for us. Because all in all, like Ms. Sparks was talking about, if we just stick with the cop and cross-examination of the cop and kind of attacking the cop's credibility without trying to maybe elicit some helpful opinion testimony or maybe present some of our own through someone else, we're kind of stuck with the state's narrative, right? Like we talked about earlier, like everyone from every jurisdiction, the prosecutors all kind of sound the same. As such, y'all probably dealing with the same types of police officers, right? Not putting down the police, but oftentimes we'll have that personality type who really wants to be seen as being erudite and kind of an expert in everything based on his immense training experience in any topic you ask him a question on. They really like to be perceived that way. And a lot of the time when we have these hearings, I kind of sense that the police will expect on direct examination for the government to let them be that really smart Sherlock Holmes character, and then they expect for us to try to make them look dumb and try to make them look like the Keystone Cops here on Cross, which, we don't really always have to do it that way. And most of the time, I come in pretty soft, and I don't really try to do that. Unless there's just there's just a huge issue. This is one such incident where this is the first suppression hearing I had where I was able to get helpful opinion testimony from the officer. I don't know if nobody can probably read this, but I got the offense report through discovery, and it had this little excerpt before the narrative where the officer, or the deputy, was talking all about how he was specialized in the criminal interdiction unit, and he's done all these narcotics task force trainings, and he's worked with the Department of Homeland Security and all this other stuff. I get we call them TCOL records in Texas. I get his officer training records. He was just a jailer a couple of years ago. I don't know where he got it. Well, I guess that's why he had to write about it, so he'd have something to talk about. So I had a sense that we'd be able to get him to opine about some things in this hearing, right? And so I did that, right? He came in, of course, as we mentioned, they're expecting us to try to make them look dumb, which is, as we all know, isn't our goal. We're trying to advance our client's theory. So I started out the cross with kind of some disarming questions, some dumb jokes, and just asking him a little bit more. He had, in this particular case, and we'll talk about it a little bit later, he had busted my client. There was a little roach in the ashtray that had synthetic cannabinoids, like the K2 spice stuff. But on the video, he's saying, whose weed is it? Whose weed is it? He doesn't identify it as synthetic until the co-defendant says, oh no, that's that fake stuff. And he says, well, it's illegal. And he's like, well, I don't know whose it is then. But so I thought it was not credible when he wrote in his police report that he smelled the distinct odor of synthetic cannabinoids. And I'm trying to think of how am I going to get this in the record? How am I going to get the judge to see that these are two completely distinct substances that smell completely different? I had a good, strong feeling that this judge knew what one of them smelled like. But, I'm trying to think about how am I going to, so I'm like, opinion. Well, ask this guy thinks, look, this is the guy who wrote this giant paragraph in this police report. So let's ask him. So I asked him, and I kind of disarmingly said, well, I'm learning a lot today. What is synthetic marijuana? Tell me about it. I know the rule of thumb we all go by is not to ask open-ended questions on cross, but in this case, I had kind of gotten to where I felt comfortable. I knew what he was going to say, and I just kind of let him run with it, and we'll talk a little bit more about that in a minute as well. Another thing they'll love, the police will often be more than happy to expound on and explain and fill the record with, right? Because that's really what we're doing, is we're building the record on what these things are to the extent that it helps and supports our claims. All the toys they have now. Oh my goodness. Every time, I feel like I get more and more cases where the discovery is these dumps of all these reports and data and mention of all these devices. I know they're not supposed to use the Stingray, but we know, right? And then there's these super expensive drones that are more than like, not just the ones like your pervert uncle has to spy on the neighbors or whatever. I mean, this is some sophisticated stuff. These SWAT robots that go in and do the protective sweep, and of course don't look at anything else. And then the ERAD scanner for credit cards, and we'll talk about these later. But if we start asking police officers for background information on all these devices, they'll be more than happy to talk all about it and brag about it, right? Narcotics dogs handlers, right? This is another area where we've been gaining a lot of ground. I don't know if anybody's familiar there. I cited in the paper there was a case out of Colorado, People versus McKnight. In states like Texas, our dogs, so Texas, we partially decriminalized cannabis. So if it has under 0.3% THC, it's legal. If it's over 0.3, we'll talk about that in a minute. But these dogs are still trained to, at minimum, be able to detect cannabis, right? So that's an issue where they're detecting things that could be non-contraband, right? Just benign, below 0.3% THC cannabis flower. Or, in Florida v. Harris, presupposes, so they say a dog sniff is not a search if the dog is trained only to detect non-contraband items, right? But that also presumes that the dog is properly trained to begin with and properly handled to begin with. That's why it's so important to get these dog handlers' records, to get whatever the agency has certified these dogs and their handlers, get all that. And then the agency itself will maintain the officers' continued training records with the dogs. And it's fun. You'll see little things in there, each time they do a little run, a little drill with the dog. Sometimes they'll copy paste from the last one. There'll be all sorts of stuff where it just looks like they just kind of ran through it. There's all sorts of things you can find out to say, hey, maybe the dog wasn't trained properly, or maybe if the dog is trained properly, it's being handled sloppily. That you can kind of tease out through that cross-exam or through getting the records and kind of informing that cross. Also, we're talking about painting the picture of what does it look like to be a handler, right? Living with the dog, all that. That's all good stuff we can draw out, but we start by getting the records. And the handlers are more than happy, again, to give that opinion testimony that helps build the record, right? And if we're who here works in a jurisdiction where marijuana is illegal, but you can have some cannabis? Right. So look at what the requirements are for your dogs to be trained in your jurisdiction, because in ours, they have to detect cannabis to even be qualified as a narcotics dog. And the terpenes, not the THC, is what gives cannabis its odor. So all these dogs should be retired. People versus McKnight is a great case. Another thing, just when we have our own experts, just now where we're segueing into here, do we give notice of as a practical matter of our expert? Is anyone here in a jurisdiction where you automatically have to give notice of an expert if it's not really? Really, Tennessee? So in Texas, the notice requirement is triggered by request, and our prosecutors don't expect an expert in a suppression hearing, so I've never had a request for notice of experts before a suppression hearing, so I just never tell them anything, right? But our notice requirement also asks that it incorporates the rules of evidence by reference, right? So it's our code of criminal procedure, but it cites our rules of evidence, and in our state, the rules of evidence don't apply in a suppression hearing. Is that the way it is in Tennessee? Do the rules of evidence apply in a suppression hearing? Oh, okay. So here in Texas they don't. So if they start complaining that we didn't give notice or whatever, that's another argument to make, is that we're not actually calling this person as an expert. And so this is a Texas specific thing. Obviously, that's not helpful to everybody, but this is just an example of kind of figuring out, well, we're doing this sort of novel thing. Do we give them notice? Do we give them a preview of it? Or do we take advantage of the fact that prosecutors just aren't expecting this? And I always err on the side of not giving that notice. Of course, if they request it, I'll give it. And then here are the types of experts we can use. I watched this really great hearing a few months ago where part of the issue was the government was claiming that the client did not have standing to object to the search because he was just squatting there. He didn't own the property, he didn't have a lease or anything else. But this particular person had been seeking adverse possession. He'd been squatting there. He'd been trying to get title to the property. He'd even filed some things with the county clerk's office. So the attorneys, what did they do? And I don't know if some of us are in jurisdictions where maybe there's less specialization with the judges, and maybe the judge does civil and criminal. In Houston, Texas, most of our district court judges who do criminal cases may not know a whole lot about civil law. That's why it's so great to bring in, as these attorneys did in Houston, they brought in an attorney who specializes in property law to talk about color of title, to talk about adverse possession, to talk about what type of expectation of privacy really, or I guess we argue on the back end that it's an expectation of privacy, but what type of ownership interest this person actually had in the property. And it was great. It was beautiful. I thought they built a great record on the standing issue, and they showed that, hey, this guy had some kind of color of title, and therefore we've got a hearing, we've got an issue. They still came in second, but it was very creative, very innovative. Here's another interesting issue with standing that I think we're not thinking about enough. I won't ask anyone to date themselves, but who doesn't know what a party line is? All right, so back in the day, especially in rural areas, right, people shared telephone lines with their neighbors. And sometimes you could hear your neighbor pick up the other receiver. I know, like, when we had a landline at the house growing up, like, I'd be on the phone talking to my friends, I could hear it pick up, like, shh, it's my dad, right? So it was like that, but with your neighbor, right? And they could pick up the extension. And believe it or not, I know a lot of people probably see this. Who here has clients who share cell phones with other family members, right? Especially those of us who are in indigent defense, right? They might have one cell phone for the whole household, and they might be sharing it, right? So, and it follows, that phone might be in the name of the person in the house with the best credit, or the person who just got paid that month, or whatever, right? So, if we have an issue with standing, as far as whose phone is this when they're trying to dump the phone, or something like that, right? This is where we look to. We need to maybe tease this out. And I put some stuff in the paper. This was an actual, it's kind of the party line litigation as far as Fourth Amendment is concerned, is kind of pre-Cats, so it's a little bit old. But there's some interesting stuff there. There was legislation passed regarding the handling of party lines. There were people litigating suppression issues with cops actually listening in on the party line. There's actually a case where they lost because the cop was the guy's neighbor and could have listened to the party line anyway without a warrant because it was his. But there's all sorts of things that we can kind of delve into. Talk about, I mean, there are experts who can talk about this custom of people sharing cell phones. Abandonment, right? So let's talk about, like, what happens when someone abandons their personal real property. Like we see a lot when someone's car breaks down on the side of the road, especially, again, with our indigent clients. They may not have the money for a tow. They may not be able to afford a monthly AAA membership to get that thing moved. And they may not be able to afford the repairs either. And so they just leave it for a little while, right? And then it eventually might get searched, it might get inventoried. And the argument may be, well, the person, even if it was their car, they no longer have standing because they abandoned it on the side of the road. Well, let's talk about that, right? Let's talk about how reasonable is it to still expect that people aren't going to go and look inside your vehicle while you're trying to get the resources to move it, right? While we're on the topic of vehicles, anybody here ever sell cars, work at a car dealership? I did before law school. And there's so much interesting stuff you can learn just by sitting around talking to people who work in a car dealership, work in that industry. One thing that comes to mind is these note lots. And I know a lot of people have these in their jurisdiction where it's buy here, pay here, there's no credit check. A lot of folks who don't have social security numbers will buy cars there. A lot of people with bad credit will buy cars there, right? And the people who run the lots, they may have less than above board business practices sometimes. I mean, we're talking about people who will sometimes print out fraudulent temporary tags, the paper tags, and put them on the back. Has anyone ever had a client where you read the police report and it said, I observed a temporary tag and typed it in and it was fake or whatever? Right? So many traffic stops start with that, right? And in your jurisdiction, see what the actual law is on who's criminally liable for that forged temporary tag. Is it actually the person who displays it, or is it the person who creates it, right? And these note lots will often, they'll convey title to people. They won't ever convey title to people. They'll just make them pay every month, and sometimes when they come in every month, they'll just print them out a new temporary tag. And depending on, again, this is highly jurisdiction specific, but in Texas, right, you get the title but subject to a lien, and you don't get the paper title until you pay it off. But sometimes on these note lots, that process doesn't even start, right? You may not even get a formal bill of sale. So when your client is challenging a search of the car and the prosecutor brings up standing, maybe bring an expert from like an F&I guy, finance and insurance guy from a car dealership to talk about the way these lots run and the practices of them. Or hell, if you've got an affirmative links issue, right? If these say it's this car, they had just repossessed the car from someone else and they're selling it to yet another person the next month, because that's a thing they do too, right? The note lots. And they never actually conveyed title to anybody who's been in all these people's driveways. Talk about it, right? Get that expert to talk about that. And then the same thing with hotel rooms. I recently had a case where my client doesn't know anybody's real name, that he was living in this kind of extended stay motel. He doesn't know any of the neighbors' names, but he knows kind of all their nicknames. So he and I went and we drove there, and we started talking about, well, who's in this room, who's in that room, and all this stuff, right? We started making a list of who all was staying where. So had already subpoenaed the booking records for that motel, get them back. Nobody was in the room that they had booked. Like, there were a few people that kind of like their names, their street names, the descriptions he gave kind of matched the IDs of the people who had booked the room. But a lot of people are booking rooms in other people's names, like as a favor, right? Especially again with our indigent clients who it's a huge burden to try to get a copy of birth certificate, go get another ID and all that, right? It's a lot easier sometimes, especially if you're living pillar to post and you just need a place to stay, to go ask a friend, hey, can you use your ID and book me a room? Talk to the people who run these motels, right? There's a lot, or maybe who used to, or who were in that industry and aren't in it anymore. This is a very, very common practice, right? For people to book hotel rooms in other people's names and then come, as a favor. But then, especially if it's an extended stay motel, the management, the people who work there, they see the person who is not the person who booked that room come in and out every day, and they're fine with it. Why? Because it's common practice. This is another expert we can use in our suppression hearings to talk about the reasonable expectation of privacy in one's hotel room, right? And subpoena the policies of the hotel chain. Because sometimes the cops will go to the front desk, hey, can I get in the room? And the hotel manager just lets them in. Right? What's the real policy? Right? Here's another thing. I don't know if folks are getting these where people are programming debit cards and gift cards with other, banking information from other cards. Right? It's, the skimming thing. Right? Well, just because your client took his debit card that has his name and maybe even his picture or the picture of his pug on it, right, and reprogrammed it with someone else's banking information, does not mean that he doesn't have a reasonable expectation of privacy in his own bank card, right? So when we're talking about this ERAD scanner, that was not this slide. But if we're talking about this ERAD scanner that the police are using to scan and read these debit cards to see what data really is on that strip, well, if it's got the guy's name and there's no reason for them to even think that there's something else on it other than, we'll talk about that in a minute, other than racial profiling, then why would they be running it to begin with? And we all know about these federal statutes that make your banking information confidential. Let's talk to people who work in a bank, people who handle that sensitive information, and maybe call them as experts to talk about what the bank's policies are on releasing your client's information. Here's some other experts, right? I know everybody, and I'm really looking forward to the presentation on these kind of bootstrap, trumped-up gang charges, but I know everybody deals with this where your client might have a local sports team tattoo or a certain color tattoo, or has just been arrested for just randomly with someone. They also think he's in a gang, and so now there's all these, like, all this training experience, I believed it was a gang thing. Let's challenge that. Right? Let's talk to people who used to be, I put the information for one person in the paper. Let's talk to people who know about gangs but who are not presently cops, right? People who have seen all the bootstrapping, people who know what really is the real deal when we're talking about whether someone's in a gang or someone's affiliated with a gang or not. Let's call those people to talk about how reasonable the officers were in aligning your client with that gang, all right? Or let's say your client did give consent, which, right, we've talked about that. We've seen that so many times where we're just like, just hold out, just don't do it, and they consent, right? Well, what about let's put ourselves in your client's shoes. Let's have the client evaluate. I had a client, for example, that I went and visited him, and I told him, I was like, they're going to come and get your DNA. I was like, I just got appointed, and I'm here today to tell you, like, it's going to happen. They're going to act like you don't have a choice. And I walked him through all the scenarios of how the cops are going to come and try to get him to sign this consent form, right? And he said, okay, I got you. And guess what happened? He gave his DNA, of course, right? So I had him evaluated. And guess what? He is extremely limited. So how knowing and voluntary was that consent? We have some other issues there too. But that's a huge deal, right? Just because someone consents doesn't mean that it's voluntary. Doesn't mean that it's done knowingly, especially if they've already been advised not to in the most thorough way possible, right? That's a huge red flag. Or a cannabis pharmacologist, right? Again, going back to just the view, officers saying they smelled marijuana and they just get a blank check to search everything. Or officers saying they saw cannabis flower and get a blank check to search everything. Get a cannabis pharmacologist to talk about the makeup of cannabis flower, the origin of its scent, as I mentioned before, the terpenes and not the THC. The things that the officers are using to base the probable cause on in jurisdictions where cannabis flower in some forms is legal, that no longer flies. But we can't just come in and say, hey, officer, you know that this is legal now, right? Because we're never, right, we're going to get blood from, it's trying to get blood from a turnip, right? The cop's just going to say, based on my training experience, blah, 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 I know it to be marijuana. I'm just going to assume it's marijuana until blah, blah, blah. Don't try to get that from the cop. Get somebody who really knows the molecular structure of cannabis to talk about why that's not okay, all right? Or lab analysts. I've even seen cases here lately, and I don't know if has anyone had a cop say, I smelled what I recognize to be the strong odor of cocaine? Have you seen that? Okay, hold on. If anybody has had 100% pure cocaine or knows where to get it, come see me tomorrow's payday. Just let me know. Because we all know that shit is stomped. I'm sorry. That is stomped on. It's cut with all sorts of stuff. How do the cops know what's giving us the odor? Is it the saccharin? Is it the maltol? What is it, right? Get a lab analyst to talk about what other things they are finding cut with this cocaine. What does it smell like? How often? I cited to some studies in the paper where they're finding like what all like common dilutants that they're using in cocaine. So, because obviously the cop is just going to say, I smell cocaine, it smells like cocaine, it's training experience, and then you're just kind of at this dead end. But if you bring this extra expert to talk about all the different myriad things that are in that tiny baggie that the person bought at the pool hall, very few of which are cocaine, right, then you've got something, right? You've got a record of, and then you can even ask the analyst, hey, so you've analyzed that substance on its own, what does it smell like? Oh, it has this odor, right? A linguistics expert, cultural anthropologist, right? There's so many times we know our clients are being profiled. We know that their window tint is fine. We know that they turned their turn signal on over 100 feet before the intersection or whatever. We know they didn't fail to maintain a single lane. We know we know that if I'm driving down the road and I've got 2 license plate bulbs, right? If one of them's out, I'm not getting pulled over, right? But someone who doesn't look like me, they're gonna bring them down. And what do we know about equal protection claims? It's so difficult because even if we can show that pattern, it's extremely difficult to show the intent that we have to prove, right? So let's do that. Let's get these linguistics experts, these cultural anthropologists to talk about the distinct characteristics of our client, all right? And we'll talk about that. I've got another slide on this. We'll talk shortly. Or digital forensics analysts in Texas. Or I guess in most jurisdictions, right? Your search warrant's only valid for so long. And we've got this really common, practice of police officers where everyone they arrest, they just assume they can just seize their phone without a warrant and just hold it indefinitely. And they do it all the time. They just kind of arrest people, take the phone, and just whenever they feel like it, they get a warrant. And then whenever they feel like it, they go dump it. Get our digital forensics analysts to say, what time did they open this phone? What time did they go in? What time did they just start swipping around on it before they actually dumped it? When did they dump it? How does that factor in relation to the expiration of the warrant? Like, that's all important stuff to look at. Or an independent expert on this policing technology, right? So some technology that the police have isn't very reliable, and they know that, but they use it anyway, and then they use it as probable cause to support a search warrant. Right? Well, if they know that it's not reliable and they've been trained on the fact that it's not on its own reliable to support probable cause, then we got a Franks issue, right? Because now they're putting things in an affidavit with reckless disregard for the truth. And again, these gang experts, right? Oh my God, clients with local, we can't just like a sports team without them trying to say we're a member of Tango Blast or the Bloods, right? And in Houston, right, we got the Rockets, so it's red, so everybody's like, oh, we've got a Rockets tattoo, it's the Bloods. It's ridiculous, right? So getting away with these snap judgments has reinforced some very tenuous explanations as to who's in a gang, what's a reasonable reason for kind of corralling someone in with other gang members, right? They just can get up there and say whatever now because, our statutes have made it just so easy to classify people. So let's start picking it apart. Let's start talking to people who, and I used Marianne Denner for a case we actually won very recently. My client had been convicted of engaging in organized criminal activity on some very flimsy evidence. And she had worked with gangs in the prisons for a long time. And she had no idea. She had, never heard of this gang. And then just based on once she understood the gang and what it was, she was like, there's no way they would have let this guy in. Right? He couldn't have gotten we also called a gang member, and then we asked him, would you have let him in? He just laughed. Well, you have to give an answer, sir. But anyway, and then odors. Again, so we talked about the odor. Actually, I already covered this, right? So the odors. Cops, they just love to just say, I smelled this, training experience, right? Let's really start picking it apart. All right, so this is how it works in Texas. And ours kind of mirrors the farm bill, the federal bill, right? So if it's under 0.3% THC, it's considered marijuana. And if it's over 0.3% THC, it's considered, other way around. Over 0.3% THC, it's marijuana. Under 0.3 is hemp. Does anybody else think it's a little bit racist that we're using the Spanish word for the one that's illegal? Right? Okay. But they're botanically identical, right? It's just selective breeding, right? So anybody here who's ever bred cattle or dogs or anything like that, right? You do your Punnett square, and then kind of how to figure out, well, I don't want a cow with black spots, or I don't know, right? Well, that's what they're doing with the cannabis, right? They're just breeding a lower level of THC. And even the federal bill even allows for a remediation, right? Or in our state bill does as well, to where if a farmer innocently grows 0.4%, right, 4% THC hemp, he can actually go back and fix it and mix it in with some lower THC hemp. So there's so much going on with this to where just saying I smell marijuana is not enough. But it's also not enough just to cross the officer. We got to call an expert to explain all this stuff and to establish it in the record as a factual matter. A friend of mine, colleague of mine, Daniel Mailer, really brilliant guy. I think it said he's working on his master's. He just got his master's degree in cannabis pharmacology. His 4.0, testifies really well. Super smart guy. I highly recommend, if you have this issue, give him a call, talk to him. We've had him testify in several hearings. He's litigated this case himself. This issue himself. He's also a lawyer. He's testified in other people's cases. He can rattle this stuff off in his sleep. It's amazing. Same with DRE cases, right? If you've got one of these stupid DRE cannabis cases where he's got weed in his system, so he must have been high when he was driving, right? Talk to him. He's great. And again, strong odor of synthetic cannabinoids. Right? We talked about this. Right? Anybody who knows what this stuff is would never conflate it with marijuana or with cannabis, right? We all know that it's this like potpourri type stuff, and sometimes even industrial grade hemp that they'll lay out and spray with all sorts of chemical nastiness, and therefore it has this kind of chemical nasty odor. It has a different, and so if you've got cops trying to use slang terms for each one interchangeably, and they've really been trained on both, call them out on it, right? Because it's if they really know what each substance is, they're not going to call this stuff weed. They're not going to call this stuff marahuchi or whatever, right? Same with the strong odor. I jumped the gun on all this stuff. So, same with strong odor cocaine, right? Let's talk to these lab analysts. This is where I want to talk about racial profiling. And I'm so glad Ms. Sparks brought up, play the Scarface clip, because I can't figure out how video clips work. But that Scarface is actually, right, that banana boat and coming over in the late 70s and early 80s, that sparked this huge racial stereotype of Cubans being inherently criminal, right? And it's something that has pervaded law enforcement for a long time now. And we have a large Cuban community where I'm from, and they're getting targeted. And how do I know they're getting targeted? How do I know they're being profiled? We had a suppression hearing in a case where, again, the body cam was on, and I guess he just didn't know that the patrol officer was targeting him with the body cam on. And our detective said, well, it's bullshit that Cubans get special status because they're all a bunch of fucking crooks. So we were like, well, we're going to have a suppression hearing now. This is going to be fun, right? And we show up, and what does the state do? What do y'all think they did? Oh, I wish. Well, no, I don't wish. Well, they dismissed it after the hearing when they lost. What they did was they prepped the officer to double down on all of that in the direct examination and to explain all about the training he's received in these Cubans and how they all do this credit card skimming scam, and how 100% of the people I've arrested for this scam are Cuban, and I've gone to Florida, and I've gone to Cuba, and I've gone to Miami, and I've tried to, and the feds have trained us on this, and what they did was they made it baked in, right? They baked in the systemic racism into this officer's training. Well, it was already baked in, right? But then they had him double down and testify all about it because they knew we were going to cross him on that video. And they just wanted to make it seem okay, I guess, which, right, it somehow it makes it so much worse, doesn't it? It makes it so much worse that he's being trained to be racist. He's being trained to profile Cubans, right? So then our burden was what? Our burden was to show that not only is there a pattern of discrimination, but that the officer had targeted our guy because he was Cuban. So then what do you have to show? You have to show that he knew the guy was Cuban as well. Because we got this rare little bit of gold of him saying Cubans are a bunch of crooks. So how are we going to prove that he's a Cuban? Who here speaks Spanish? Okay, Spanish speakers, if you have a hard time understanding Cubans, put your hand back up. It's extremely difficult, right? It's because they have such a distinct dialect. They have such a distinct way of speaking. So we found this really great cultural anthropologist to talk not only about kind of the more typical, or I guess the more Arawak features that a lot of Cubans have, but also those different I guess, patterns of pronunciations and the different distinctions in their dialect. And it was wonderful. He really kind of, to me, kind of laced it up to where not only do we have the cop saying these terribly racist things on the video, and not only do we have him, thanks to the state, testifying about this pattern, this nationwide pattern of discrimination of profiling Cubans because of the credit card scam, well, then we also have additional testimony explaining how he would have identified my client as a Cuban as soon as he got him out of the car, right, by the way he spoke. And then think about this also from an exclusionary rule perspective. This is kind of a novel thing. We have in addition to the Fourth Amendment exclusionary rule, we have a statute in Texas where we can have illegally obtained evidence excluded, and it's a little bit more broad. So that's what we're arguing is, hey, look, we have a statute outlawing racial profiling in Texas, and he racially profiled this guy, extended the detention based on that profiling, and therefore it should be suppressed. We ended up winning on other grounds, but I guarantee you the judge did not want to say, right, he did not want to deny our motion after hearing all these things about this officer's attitudes toward Cubans. While we're on the subject of the cards, right? Again, so this device, they just willy-nilly will just take someone's wallet, seize it, pull all the cards out, another search, right, and start running all these cards. And a lot of them are bank cards. A lot of them are gift cards that are issued by a bank. All right, we need to be complaining about this because even if it says a gift for you for the cardholder name, if it's issued by HSBC Bank or whatever, right, that's banking information. Even if it's a prepaid green dot, right? And again, think about our indigent clients who maybe have a hard time getting a bank account or keeping the bank account open, right? Or keeping from having overdraft fees and maybe moving from bank to bank. If they're kind of the last house of the block and doing these prepaid debit cards, why should they have less of a reasonable expectation of privacy in their banking information than anyone else? All right, why? So let's argue it. Let's litigate it. There's some bad case law so far coming, and I cited some of it in the paper, but there's distinguishable facts in those cases as well. Like some of them are just, they'll find someone with a big package of like 100 blank gift cards, right? So they said, well, that's not, you don't really have a reasonable expectation of privacy in something like that that's, obviously contraband, obviously kind of a little weird. Robots. I love this robot thing. Has anyone here had a protective sweep robot yet? I think it's kind of new. So what they're doing is they're getting arrest warrants, not search warrants, and then they're sending the robots in, and the robots can go up the stairs, they can go around all these corners, they can do all this stuff, and they're looking for people right before they send the jump out boys, the SWAT team in, because why would we not have paramilitary cops in like every jurisdiction now? So, but they give them all these fancy, sophisticated toys, right? And that robot can get in places and look at things that a person can't. Let's talk about it. Let's ask the cops about it. Let's find these vendors. Let's investigate. Let's find out, what does it cost to get one of these? What can they do? How remotely can they run through there? And then, of course, in your case, get the video. See where it went. Go to the scene. See if it could fit in there, right? It's only a matter of time before these robots go beyond that scope of the protective sweep, and then we've got something to work with, right? Has anyone seen the heat vision, night vision videos in your cases? Right? This one's from the movie Predator. This isn't from a case, right? But this is, I could not believe this. And these helicopters, they're following my guy around, or allegedly my guy, and the other folks that were suspected of this, and they had these heat vision cameras, and the officers are actually talking to each other. So on the video, I guess they also recorded their discussion on the walkie-talkies while they're doing this. And you can tell which car's been running the longest, right, by how hot it is. And they're following them all over the place. And at one point on the video, the cops are like, should we be getting a warrant for this? Right? Let's talk about, this is classic, this is Kylo, right, v. U.S. And I would argue, right, that we should be talking about Kylo when we're talking about robots. We should be talking about Kylo and Riley when we're talking about the debit card, the ERAD scanner. And then when we have an expert, this is some kind of regular nuts and bolts expert stuff. I always prepare a file for them. I kind of curate the information that I give them right out the gate. Because if we're calling an expert, oftentimes, right, we're trying to explain the bad optics of our case. So one thing I always do is when I do my expert file, I'll put together a little index, and if it's a document, I'll bait stamp it, and I'll have everything kind of indexed by bait stamp number on there. And I'll even, like if I have a video, I'll put together a little index of all the timestamps of relevant things that I want them to look at, because how many times have we hired an expert, and God love them. I'm not accusing anyone of being lazy or anything, but sometimes we start asking them about, hey, did you see this? Did you see that? And they're like, okay, let me make it easy for you. Index it, right? And then that way, especially, so once we've got it all bait stamped, we see, we've got 3,500 pages of documents then during our direct examination. And how many pages of documents did you review in your preparation for your testimony? Then what are they going to do? They're going to know, well, yeah, you gave me the index. Right? And then we meet with our experts, we reference the documents. And then sometimes I will meet out the information. Not to say that I'm like giving a false impression or I'm holding back material information that is important to their opinion, but I'm not going to give certain things right out the gate, right? I'm going to give them the things that I really want them to look at and start developing an opinion about, and then I might meet out something later. For example, I had one where my client was saying that there was a malfunction with the car that caused her to drive it into a person. And so I got an automotive engineer, and I put together an expert file for him, and I put the surveillance video in there, which shows her arguing with that particular person beforehand. And then even though it was wild because we had all these conversations about that particular car and how there was a recall on the braking system, and how on that particular car with that type of throttle system, the computer would actually mitigate the signal from the gas pedal to the throttle if it knew there was something wrong with the brakes, and how he had even driven a car for 30 miles an hour down the interstate because it had that same issue, because it had a problem with the braking system, because it had that type of throttle and that type of computer. And could I get him to see that my client might have had that same issue? No, because I'm a dummy and I put that surveillance video in there and he saw that she was having an argument with the person beforehand. Right? So the same bad optics that cause us to seek the explanation can sometimes cause our expert to have the same cognitive biases that we're trying to overcome. So I kind of tell on myself and give that story because I think it's a great example of a bad decision. And then I like to have a few meetings, and I know, especially since I feel like we have more meetings since COVID. Like now, everybody can just say, "Here, I sent you a link. Let's talk at 3." I know we're tired of having meetings, but I like to have a few meetings with the experts, right? So the first one is where I kind of like lay it all out. I talk about potential theories. I talk about my goals and what I want them to look at. And then we start getting organized. And I say, hey, here, I'm going to put together the Dropbox file. I'm going to share it with you. I'm going to give you the index, all that, right? And then I'll say, we'll talk again in a couple weeks. And then once they review everything, we'll have a discussion about their opinion, right? And I don't want necessarily a written report until we've really talked it out. And then once the preparations start for the trial or the hearing, whatever we're having, then the meetings will become more pointed, and then we'll start basically doing a little dry run on the testimony a little bit, right? Seeing what sounds good, what doesn't. And I like to have one where we eventually, after we've kind of like woodshedded a little bit of testimony, do a rough outline, run through it with them, and just kind of see how they sound, maybe whittle it down a little more, and then no matter how much we do that, no matter how much we do like a dry run of the testimony, I like to do one like the morning of or the day before the hearing, because just something happens that last couple of days. Like a lot of, especially if people maybe haven't testified as much, they'll kind of consult with other people in their field, and they'll get all these other new ideas that they're trying to inject in the testimony last minute. I've seen that a lot, so I like to have another meeting like right before we do the hearing. To go over everything. And then, of course, if you're in a jurisdiction, if you're fortunate enough to be in a jurisdiction like mine where the notice requirement is only triggered by a request and no one ever requests it for a suppression, you'll kind of get the standard, just off the cuff cross-examination questions that they would just come up with on the fly, right? So they might, if they do, right, if they do get notice, then they might get your expert's prior testimony, right? So it's a good reason, especially if you're on a listserv, especially one of these national listservs where everybody's sort of sharing prior transcripts. Get on there, vet the expert, right? Get the prior testimony, prepare for that cross-examination. Because if your prosecutor's worth his or her salt, they're going to do the same thing. And if they've got notice of your expert, better believe they're going to get on their listserv. Hey, do we have testimony of Dr. So-and-so, right? And then they're also going to ask questions that suggest your expert is not competent to render the opinion or has gone outside of his or her area of competency, right? So make sure to prepare. If you haven't already front-loaded this on direct examination, prepare for those questions. Prepare to redirect the expert on that, right? On really delving into, you gave an opinion about this, and your experience is this, and X, Y, Z, right? You expect some questions that suggest the expert has not reviewed the specifics of the case, right? Again, that's where I recommend, I've got everything in the file for you. Just have the index handy and ready to go. Don't sit there and read it in the middle of the thing, but you can reference and look down. Well, if my last Bates number is 4,000 something, you can say, well, I've reviewed 4,000 some odd pages of documents, right? Talk about, it's really important that you remember that all the things I gave you to review, and that you remember that when you're testifying, because they are going to cross you and act like you just fell off the apple cart, right? Or questions that try to inject the idea that your expert has relied on certain assumptions, right? Or has trying to highlight some sort of fallacy in your expert's reasoning. Or if your expert has been published on some topics, that's something that even if you don't give notice of the expert, they can sit there and Google your expert on direct examination. They can find things that your expert has published, and they can sit there and read them. Very recently, I'm preparing for a trial where we have a particular expert, and just maybe 2 weeks ago or so, a Court of Appeals opinion came out saying that it was an error to exclude his testimony, and even used the word charlatan, right, in that opinion. And that opinion didn't exist 2 weeks ago, but fortunately we found it. Now we're going with somebody else. But look out there. Look out what all is in the public domain with your expert's name on it, right? Because especially if you're in a jurisdiction where you don't have to give notice, that's the first thing the prosecutors are going to do while your expert is testifying is Google, find things, and use that on their cross. And then, of course, we're going to have to deal with objections to this testimony. And obviously the common thread in all these is and I know we have this in every jurisdiction, the way we always do things around here doctrine, right? So when you're coming to a suppression hearing and the judge is saying, okay, we're going to put on the comp and then we'll go have lunch and then I'll come rule after lunch, right? You're going to anticipate these objections because it's not the way we do things, right? So the objection might be, whoa, judge, hey, this is just about a traffic stop. This is all this extra expert testimony is irrelevant. Well, hold on. Your Honor, I heard that officer on direct examination say training experience and give opinion testimony. All we're doing is rebutting that opinion testimony that the state presented. So now we're in our case in chief, right? Or an objection under the rules of evidence, right, that the expert is not qualified to render their opinion, right? So highlight that expert's specific qualifications and how the witness can assist the court in making reliable findings of fact and conclusions of law, while noting, or in Texas anyway, that the rules of evidence don't apply in the hearing, right? Because again, your judge knows that his or her paper is going to be graded as well. And it's just as much error to exclude testimony sometimes, right, as it is to rule the wrong way based on whatever, erroneous findings. So, or object, of course they're going to object to lack of notice a lot of the time. And this is a state-specific response. Or objection that the legal analysis is not an appropriate topic for witness testimony. So with our cannabis cases, right? We have this sort of intersection of legal and scientific definitions. And they might say, well, this guy's just a lawyer testifying about what cannabis is. Well, hold on. Well, this taxonomy and the selective breeding and everything, that's what the law is based around. We're saying it's legal, right? This is all relevant. Or property rights, whether the person has a reasonable, they might say, why do we need to hear from a property law attorney about adverse possession? The lawyers can argue the law. Well, hold on, no, this is about developing as a factual matter in our record whether our client has a reasonable expectation of privacy in that residence. That's the whole thing that the state has objected to by saying that he lacks standing, and we're entitled to show that he does, right? And of course expect, again, the judge, they're trying to get out of here by lunch, right? So expect them to try to exclude your witness and try to say, well, no. And we're very fortunate in Harris County now to have a lot of judges who used to be defense attorneys and well-trained defense attorneys like all y'all, right? And so a lot of the time that hurts us because sometimes the judges will assume what we're getting at before we get to it because they did our job, right? So you might hear something like a judge say, hold on, the court is very familiar with this concept. When I was a defense attorney, I went to Vegas and went to this training, and we don't need to hear this testimony. And then the response is, well, hold on, Judge, we're not seeking to educate the court, but rather to establish as a fact this concept, right, as a factual matter for the record on appeal, right? Because it's our burden to show that this was error. Or the state's objection will be sustained as the entire breadth of the testimony. Okay, well, I understand your ruling, Judge. May I make a bill, right? And so I understand that you're not considering the expert's testimony, but may I make a bill? May I have the testimony that I would have offered on the record for the Court of Appeals? What's being excluded, right? Make an offer of proof, whatever you call it in your jurisdiction. The state's objection might be sustained as to one question. That's one thing I love about having hearings outside of the presence of the jury. You don't have to have the jury taken out and then get the bill made off without them in the room. You can just stand up and say they object, and then the court sustains it. You can just say, well, may I have the answer for a bill? And you get to hear it anyway, right? Unless you do it for like every time, and then eventually you just have to make your bill later. Or the court completely fails to see the connection between the proffered testimony and any logical suppression argument, right? So this is where I know the best practice, or at least I don't know how y'all have to do it, but we usually do a very scant boilerplate motion to suppress when we get the hearing, and then as we get closer, usually on the eve of or on the day of the hearing, we'll file our full brief with all of our arguments and everything, right? And I don't like to show my hand. I don't like to give away what my case is going to, especially if I'm bringing an expert and all this kind of novel stuff that I don't want to give them a heads up about, right? So if we're in the state's case in chief and the court doesn't see the connection yet, or they've just closed and we know they're going to be able to rebut, I've been holding back on this the whole time, right? My skeletal argument that I'm going to make at the end, the argument I'm going to make at the end. So I got to make an offer of proof now, right? If the court is completely excluding this whole area of testimony on the basis that it's not relevant, okay, Judge, well, here's why this is relevant. Here's what a little bit of what we're going to argue at the end, all right? Make that skeletal argument and say, Judge, I would proffer that this is all relevant for these reasons. All right, and then of course there's always the judge just will not let you get a word in edgewise, which you cannot read that in the record when you're being yelled at. I've read records of my own hearings where I'm like, no, I know there should be an exclamation point there. But just say, may I be heard? Judges know. That's the magic word that they know the Court of Appeals is going to be able to tell. They're not letting you speak. And that's it. That's all I have. Anybody have questions?
The CLE verification code for this program is 3V5389. 3V5389.
So she was asking, where do we look for experts on police practices, like to rebut the training experience stuff, or to talk about policing from, from our side? And the question is, well, isn't this kind of duplicative of what the state just offered? Aren't you just asking your buddy to kind of give the other side of the coin? And isn't this just Is that what you're? Right. So Daniel, for example, Daniel Mailer, for example, he's a lawyer, but he also has that pharmacological, that scientific background. So there's sort of the distinction that, look, he knows things that we don't know, right? He knows things that the lawyers on this team are not trained to deal with directly. And with all due respect to the court, maybe he knows some things that the court doesn't know, right? And proffer them that way. As far as, are you talking about the gang thing too, or just the legal? So another would be, so the property law expert we saw, that was like his niche practice area, and as I mentioned, like Houston's a lot more specialized. So I think our judge really appreciated having someone who was a civil lawyer to come in, because it's kind of, when everybody, especially in a jurisdiction where everybody is more specialized, it seems okay most of the time for a criminal lawyer to come in and say, I don't know anything about this particular area, and the judge will usually think it's okay, or usually allow it. As far as the other side of the policing coin, usually folks who have worked with police and don't anymore, for the gang stuff, for example, that's a good place to find them. Was that? But I don't think that was actually part of your question. No, just ask around, right? Ask for referrals. Talk to people. Yeah, talk to law professors. And that's how we found Dr. Duani, the anthropologist. Right? We asked around and called different universities in Miami and kind of and then we started vetting them with other folks. And I guess we do the same thing with lawyers, right? Just ask around your local bar. Well, that's a good question. I wish I had a good answer to that. I don't know of like that would be a great, like 50-state survey of who's got them and who doesn't. That would be great. I do know, though, I mean, at its fundamental core, right, the officer has to have probable cause. And if one of the factors that amounts to probable cause is this, racial factor of it, I think we can all bring that argument that, hey, look, the officer has articulated X, Y, Z as the reasons for the stop or the search or whatever, but that by itself isn't enough. How did he get to probable cause? Well, we know it was because of profiling, right? And then there's McCleskey v. Kemp is a really good resource. There was also, I can't remember, it was, I think it was out of Ohio. There was a study where they actually went and looked at all of the traffic stops over a certain period of time and the ethnic makeup of the people and the reasons for the stop. So there are resources out there where people have monitored this stuff, but as far as the actual, what states have racial profiling statutes and which ones don't, I would love to know that. Yeah. And this gentleman, I'm sorry. California does? Okay. I haven't dealt with it yet, but I think we're going to be seeing a lot of fights over Delta 8, right? Because, I don't know about in Minnesota, but in Texas, so you can't just have THC, right? But then it also talks about analogs of THC and different things that they make from THC, right? Which would be Delta 8, because as I understand it, so Delta is on a molecular level, Delta 8 and Delta 9 are like a mirror image of one another. It's kind of like I guess that's what it is, right? It's an isomer. It's and again, call Daniel, don't call me, because I can't articulate it. But it's enough of it derived from Delta 9 to where I think we're going to have that problem. So there's so everybody can hear, there's a California mandate in 2018 that required the officers to report the racial makeup of everybody they stopped and the reason for the stop, but as far as we know, it hasn't been published yet. Okay, that's good to know. Well, thank y'all so much for having me. I've had a blast. I'm looking forward to the rest of the week.